Hello, this is a broadcast by the Utah Land Use Institute. We are sponsoring a series of topical um, workshops on different land use issues that are current in Utah and important to understand. This project is funded by a generous grant from the Utah Division of Housing and Community Development, part of the Utah Department of Workforce Services. We also appreciate funding by the 1% Building Permit Fund from the Utah Property Rights Ombudsman. These funds are available to build our land use library and will help cover the cost of making these materials and streaming video available permanently at our website at utahlanduse.org. There's a tab for the land use library, and that's where these materials will be found. We also have a tab on the workshops page for this particular workshop, and that's where the PowerPoint can be located. And that, of course, is on the screen now for you to view. So whether when you view this at some time in the future, this PowerPoint will be available and essential to have because the content is detailed and acts as a great, almost a handbook on the topic we're discussing. The CLE is available for those who are viewing this online. We also want to encourage whatever conversation is prompted. Happy to have this in a less formal manner and to support Jordan in his comments by engaging on issues that we have additional thoughts on. So having said all that, let me turn the time over to Jordan. Jordan's the lead attorney in the Office of the Property Rights Ombudsman. He's been there for a number of years. And before that, served as a planner. So he comes to us with a good background in both disciplines and is just the right person to conduct our conversation today. So, Jordan, please take it away.
Okay, I'm gonna bring my screen up here. Thank you, Craig and Wilf and Karina for having me. Hold on one second here. All right. How's that looking? See it? Great. Okay, well, again, thank you for having me. Craig, my name is Jordan Cullimore. As Craig mentioned, I'm the lead attorney in the Office of the Property Rights Ombudsman. This was a presentation that I originally gave at the spring APA conference, and Craig was in attendance, and he asked me to provide it here as well in a recording for the Land Use Institute. So I'm calling this my encore presentation, right, of moratoria and related tools. So anytime I give a presentation, I like to start out just by introducing the Ombudsman's office, who we are and what we do, because ultimately our office acts as an independent, neutral resource in the land use arena to all the players, to developers, to property owners, to local officials, elected, appointed, as well as staff. We like to try to help everyone and provide information as well as dispute resolution tools. So here's our website, propertyrights.utah.gov. There's some great information on there. As far as what our office does, a lot of what we do is we just talk with people through trainings, also over the phone. You can call us. We try to be accessible. When you call in, we try to connect you with an attorney so that you can get your questions answered quickly. And we answer questions for, like I said, everyone involved in the industry. We also provide dispute resolution tools. The two main tools that we provide are the advisory opinion for land use matters. So if you have a question about how a legal issue should be addressed related to a land use application, you can come to our office, you can request an advisory opinion, and that acts as a tool to help resolve disputes that arise in that context. We also mediate property rights disputes. Most of our mediations occur relative to eminent domain and takings. We can get additional appraisals for property owners so they can have another data point. about value and those types of things. And then finally, like now, we also go throughout the state and provide in-person trainings. So that kind of in a nutshell is what we do. Our office, there's 3 attorneys in the office. We have an assistant, and then there's also a recently created position. Rob Terry is he has a planning background, and he has been hired to kind of coordinate training efforts throughout the state. And so there's a lot of exciting things going on in that realm as well. So I'll put my contact, go onto our website. You can get all of our contact information. I'll also put my contact information up at the end of the presentation. Please let us know if you have questions. Okay, so the reason I came up with this presentation, kind of the thought behind it and where I got the idea from is in the time that I've been here with the Ombudsman's office, we regularly, like I said, talk with people and get calls from people. And frequently and often, we'll get calls and someone will say, "Hey, there's a moratorium. The city has a moratorium." And I've learned over the years that I need to dig a little deeper whenever someone says that there's a moratorium, that the city has put in place a moratorium, because it means different things to different people. A moratorium, a pause. Essentially, what it is the city has told me that I can't submit the application I want to submit, or they won't consider the application I want to submit, or different rules apply to the application I want to submit than what I think should. And so, as I've talked with people, I've learned that there's basically 3 types of scenarios or tools that are regularly referred to as a moratorium. And I put them into these 2 buckets. So the first one is discretionary legislative decision making. The entity is not accepting or considering new zone change applications. Sometimes someone will say they put a moratorium on zone change applications. And then the other 2 are related to exceptions to the vested rights rule, which we'll get into as the conversation here proceeds. But one is a temporary land use regulation, and then also a pending ordinance. So we're going to talk about each of those, when it is appropriate to use them, kind of the legalities surrounding each of them, what they mean, and those types of things. So the first one is the entity is presently not accepting or considering new zone change applications. So the common question I hear is, so I went into the city to submit an application for a zone change. They told me there's a moratorium on changing zoning, applying new districts to new areas. Can they do that? So to answer that question, we kind of have to step back and talk about the fundamental distinction that we always have to address first in the room when we're talking about land use decision making, and that's the distinction between legislative and administrative decision making. So going back to civics class, we have legislative decisions, we have administrative decisions. When a local government is making a legislative decision, and you see on the screen there, we're talking about policy making. Okay, we're talking about amending the general plan, we're talking about enacting or amending land use ordinances, development standards, zone changes, annexations, and then where there are legislative changes, development agreements as well. So in the legislative realm, the body making the decision is the legislative body, right? So for cities, it's the council, city council. For counties, it's the county commissioner, the county council, the legislative body. They're the only ones that can make legislative decisions, and the courts afford them a lot of discretion in the decisions they make legislatively because they're making policy. They're deciding what they want their community to look like. So as far as the legal standard that a court would apply to determine whether or not a legislative decision is valid, it just has to be consistent with applicable state and federal law, which gives a lot of latitude and broad discretion. And then otherwise, it just has to be reasonably debatable to be in the public interest, and also with the Land Use Development and Management Act, which we'll talk about a little more here moving forward. But ultimately, legislative decisions, you're making policy, you're deciding what your community wants to look like. And then administrative decisions, now, the pendulum swings the other way a little bit. And with administrative decisions, it becomes a technical inquiry. So we're just applying existing codes to a particular proposal. We're talking about subdivisions, conditional use permits, site plans, building permits, um, variances, and then also kind of more technical development agreements that don't create new standards, but just are applying existing ones. And in the administrative decision making, the discretion is significantly narrowed, right? So you're looking at the rules that apply, and you are just simply applying them to the application and making sure the application conforms to the rules. And then with any factual determinations or discretionary decisions, you have to support it with evidence. It can't just be based upon opinion or preference or things like that. So with that foundation laid, when we're talking about whether or not a local government can say, hey, we're not accepting new zone change applications, again, we're looking at that standard that the courts apply to say, okay, is that within the legislative body's decision to say, you know what, we're good with the zoning right now and we're not changing things? And usually the answer is yes. So this comes from um, uh, a Utah appellate court case from the year from 2000. The court said in zoning, as in any legislative action, the functioning authority has wide discretion. Its action is endowed with a presumption of validity, and it is the court's duty to resolve all doubts in favor thereof, not to interfere with the entity's actions unless it clearly appears to be beyond its power or is unconstitutional for some reason, as it deprives one of property without due process of law, or capriciously or arbitrarily infringes upon his rights therein, or is unjustly discriminatory. So with those few caveats, generally speaking, a legislative body has broad discretion to say, okay, here's what we want the policy of our community to be. And so, you know, if a legislative body has made the decision that we like the zoning as it is and we're not really making decisions, in most cases, a court isn't going to overturn that policy that they have. So as far as it being a moratoria, a long-term solution, there's a few considerations to keep in mind, right? If you're going to put a categorical pause on zone change requests, make sure you have a good reason why, number one. So maybe your community has just recently gone through a very exhaustive process. You've done, you know, economic analysis. You've looked at zoning in throughout the city. You've considered, you know, recent changes to state law that require you know, your water plan, your moderate income housing plan, and you feel like you have a really good scheme in place that checks all the boxes and is going to be a great guide to future growth in your community. If that's the case, then yeah, maybe saying, hey, you know what, for a while, we're going to see how this goes. We're not going to consider new zone change applications. We're just going to leave things the same. It's probably appropriate for a community to do that. At the same time, I'd recommend avoiding using it as a broad and sweeping tool. In other words, just a categorical, you know what, no way, no how, in no case are we going to ever entertain a zone change. This next one, municipalities specifically should avoid using it as a long-term solution. Again, I'll caveat that with don't use it as an anti-growth measure or something like that, right? You might start running afoul of issues if you do it that way. The thing to keep in mind ultimately is municipalities exist to provide municipal services, to facilitate the orderly growth of land, and you want your zoning scheme to be in a state and a condition that pursues that goal. A few red flags, right? So if you hear a property owner say something to the effect of, hey, I under the current zoning, I can't do anything with my land. We need a zone change. The US Supreme Court about that said, we think in short that there are good reasons for our frequently expressed belief that when the owner of real property has been called upon to sacrifice all economically beneficial uses in the name of the common good, that is to leave his property economically idle, he has suffered a taking. So that next line is this is often as an as applied concern as opposed to a facial one. So often courts will address facial challenges versus as applied challenge. A facial challenge to an ordinance says this ordinance in and of itself as written is unconstitutional, right? So if you arguably had an ordinance that said in this zone there are no permitted uses, right? That would be facially unconstitutional. Most ordinances don't say that. Most ordinances do, you know, most zoning districts allow certain uses. But that zoning district as applied to a specific property, and considering that property's conditions and circumstances, renders the property useless or uneconomically useful. So that's an as applied, right? So the zoning district as applied to my property doesn't allow me to do anything. If that's the case, then, saying, we're not going to allow zone changes here, that becomes a problem, and you could potentially be affecting a take. This next one, admittedly, when I first put it in and when I did the presentation originally, I thought of it more as kind of an aspirational thing to keep in mind, something to just remember as you're making decisions. So I have in there that provision, or the statement from Harmon v. Draper, that your decisions can't be unjustly discriminatory. Now, I think probably when that was stated, and generally speaking, that's thought of and viewed as applying to what we refer to in the law as protected classes, race, age, nationality or national origin, sex, those type of protected classes that the Constitution and the law doesn't allow you to discriminate again based upon those categories. And admittedly, if you are making zoning decisions or not allowing zone changes for those reasons, then you're going to run afoul of constitutional issues. But in today's climate, I think it could mean and may mean even more, right? So I put up there the general rule that's cited from a Utah appellate court case. And this is kind of what the courts have laid out and what we talked about as far as legislative decision making, that if a legislative decision could promote the general welfare, or even if it is reasonably debatable that it is in the interest of the general welfare, the court will uphold it. The Land Use Development and Management Act, so the state statute governing land use in Utah, it adjusts that standard a little bit, in my view, right? It says a court shall presume that the land use regulation properly enacted under the authority of this chapter is valid. So everything's good to that point, right? And determine only whether the land use regulation is expressly preempted by or was enacted contrary to state or federal law. So again, it can't be illegal based upon some superseding law. But then it changes the reasonably debatable language a little. It says it is reasonably debatable that the land use regulation isn't just consistent with the public interest, but is consistent with this chapter. In other words, consistent with the Land Use Development and Management Act. And in recent years and currently, we know that there's a big focus on housing availability, housing affordability. A session or two ago, the legislature put into the purposes section of the Land Use Development and Management Act an additional purpose that so you kind of see the normal purposes, right, that we traditionally think of, providing for the health, safety, and welfare, promoting prosperity, protecting the tax base, those types of things. Recently, the legislature added that one of the purposes of the Land Use Development and Management Act is to facilitate orderly growth and allow growth in a variety of housing types. So arguably, your zoning scheme may be discriminatory if it doesn't allow for orderly growth and allow growth in a variety of housing types. Rick Plen, one of the attorneys in our office here, he brought to my attention the other day a 1975 New Jersey Supreme Court case, Burlington NAACP versus Mount Laurel Township. And again, as I understand it, New Jersey went through a lot of the housing affordability issues years and years ago in the 70s and 80s that Utah is just now starting to experience. And the court then ruled that a zoning ordinance that only allows single-family residences was an abuse of the police power, in that it discriminated against low-income families. So that's one thing to keep in mind and consider as you're deciding, okay, does our zone scheme look good? And are we not going to allow new zone changes? Does your zoning ordinance allow for a variety of housing types? Does it unjustly discriminate against different economic categories and individuals looking for different housing types?
Jordan?
Yes, Craig.
I just wanted to echo your sentiment there. This is kind of on the a new adventure in Utah land use, because the addition of that language into the Land Use Development Management Act for both the county and the cities opens up a new opportunity for challenges. The Mount Laurel case is legendary.
Hmm.
In that case, the New Jersey Supreme Court found that Mount Laurel had discriminatory practices and ordered them to allow apartments. And they didn't have this language in their enabling act.
Yeah.
So this is ripe. And one of the things, just as a practice tip and a suggestion to locals, is you've got to you've got to make sure that your city council is not just offering random comments about the reason for their decisions in the record. Because if I may quote another case down in Bluffdale, the Moderate Income Housing Act was the subject of a case brought by Anderson Development. This is some years ago, where apartments were being proposed for Bluffdale, right at the corner of Redwood Road and the Bangerter. And the city council members on the record said, this Modern Income Housing Act is just kind of, we can just pretend we're doing something, it won't matter. The trial court judge in that matter was a certain Judge Durant, who is now the Chief Justice of the Utah Supreme Court. And he made no bones about it. He basically said in his district court opinion, if I hear any more of that kind of chatter, we'll be assigning all of Anderson Development's legal fees against Bluffdale City. So
No.
that's old news, water under the bridge. But this is a place where local government should take particular care to make sure they're not open to the suggestion that they're not following as one of their major goals the purposes of the Land Use Development Management Act, which includes housing types, for what it's worth.
No, thank you for that comment, Greg. So again, I just kind of indicate there the guiding principle when we're talking about, the discriminatory aspect of being treat similarly situated individuals similarly and also don't exclude. Um, as far as, the question of a moratorium on zone changes, those are just some considerations and thoughts to keep in mind, both for the local government making the decisions as well as any applicants who might come in seeking to change the zoning on their property at any given time. Okay, any other comments or questions or thoughts at this point? I welcome everything. Okay. Moving on to the next bucket of tools that I've heard to refer to as moratoria. Now we're getting into exceptions to the vested rights rule. So before we get to temporary land use regulations and pending ordinances, I'll just take a quick minute to review vested rights. Western Land Equities versus Logan is a Utah case from 1980. It's kind of the seminal land use decision establishing vested rights in Utah. It says a property owner should be able to plan for developing his property in a manner permitted by existing zoning regulations with some degree of assurance that the basic ground rules will not be changed in midstream. So the whole kind of policy consideration underlying and legal consideration underlying vested rights is kind of this balancing between the public interest in pursuing that, balancing it with property rights and predictability and certainty with owners knowing what they can do with their land. And if you do a kind of a survey of the United States and look across all the different states, you'll see a variety of different rules related to vested rights. In other words, so the question is um, when do the rules applicable to a land use application lock into place so that everyone knows what applies? And when can a local government retroactively say, you know what, there's something wrong with this application and we need to apply some rules that weren't enacted when the application was submitted, but we think are important, right? You obtain a vested right in Utah at a different time than in some other states. So in some states, that doesn't happen. You don't obtain a vested right to the ordinances in place until the property owner has made significant investment into the project. Sometimes even, the improvements need to be coming up vertically out of the ground before a court will say, yeah, local government, you can't change the rules anymore. Here in Utah, the courts we're an early vesting state. So both in Western Land Equities and now in statute, it's been codified You'll find it in the municipal LUDMA 109A 509. So an applicant who has submitted a complete land use application, including the payment of all applicable fees, is entitled to substantive review of the application under the land use regulations in effect on the date of the application is complete and applicable to the application or the information shown on the application. And then they're additionally entitled to approval of that application uh, once the application conforms with all of the regulations in place. So the vested rights and rule in Utah is that the rules lock in place as soon as you've completed or submitted a complete application and paid all applicable fees. Um, Sometimes the question comes up, what's a complete application? Essentially, it's everything that, and in short, right, it's everything that the local government needs in order to begin review. One thing I really appreciate about recent changes to the subdivision approval process is the new statute indicates, okay, local government, you need to outline everything that needs to be in a subdivision application. I think every local government should have that in their local ordinance. What constitutes an application? What documents you need in order for there to be a complete application? That removes a lot of the uncertainty. But essentially, once you submit a complete application and pay all applicable fees, then your application vests and the local government can't change the rules applicable to that application. There are always exceptions to the general rule, though, right? So Western Land Equities did say a rule which vests a right unconditionally at the time application for a permit is made affords no protection for important public interests that may legitimately require interference with planned private development. If a proposal met zoning requirements at the time of the application but seriously threatens public health, safety, or welfare, the interests of the public should not be thwarted. So that's kind of what we're talking about right now. Is we're talking about what are exceptions to the vested rights rule. And the first one, because there are a few, right? And the courts recognize that there sometimes needs to be exceptions or situations and cases in which a submitted complete application may have, the rules applicable to that application may need to change based upon certain circumstances surrounding the application. So the first one is the temporary land use regulation, and this I think is probably what we mostly think of, at least in the land use industry, when we refer to a moratorium. Um, so a temporary land use regulation, it allows basically the local government to impose, again, temporary regulations based upon some sort of a serious public concern or exigent circumstances. And in certain cases, it can pause existing applications or even send a signal to new applications that, hey, there are new rules that apply here, right? So temporary land use regulations, when or under what circumstances can you enact them? So except as provided in subsection 2B, which we will talk about later, a municipal legislative body may, without prior consideration or recommendation from the Planning Commission, enact an ordinance establishing a temporary land use regulation for any part or all of the area within the municipality if, and then there's two circumstances, a legislative body makes a finding of compelling countervailing public interest or the area is unregulated. So the first signal is the part I have in italicized there. One to kind of recognize kind of the discretion that you should exercise in using land use regulations and a signal that the cases should be infrequent is that due process is suspended, right? You don't have to go to the city council doesn't have to an extent, it's suspended. You don't have to get prior consideration or recommendation from the Planning Commission. The Planning Commission, by state statute, is where the public hearing occurs. So the public has the opportunity to be heard. If there is some sort of an exigent circumstance, immediate public concern, then you can enact a temporary land use regulation without that aspect happening, right? And then secondly, there's the two scenarios, right? So the legislative body makes a finding of compelling countervailing public interest or the area is unregulated. The second one, admittedly, I don't know that I've run into that at all, honestly, in the time I've been around, if any. When annexations occur, the annexation code indicates that land being annexed in should be assigned a zoning designation. But assuming maybe for whatever reason that didn't happen, or you're in a county and there's an area that just happens to be unregulated, then yeah, you can enact an ordinance, that a temporary land use regulation that applies both to new and existing applications, and says, hey, we're putting a pause here for a moment. And we're gonna look at some things, right? But the more common one we see is the compelling countervailing public interest. So we'll get into that a little more here moving forward. And then what can the regulation do? It may prohibit or regulate the erection, construction, reconstruction, or alteration of any building or structure or any subdivision approval, right? So even where there may be a vested application, again, if you can make a finding of a compelling countervailing public interest, then you can overcome the vested rights rule and potentially have a retroactive application of a land use regulation. And then you also see what it cannot do there, right? It can't impose an impact fee or other financial requirement on a building development. For how long? It can't be longer than 6 months, no more than 180 days. So the idea here is you've identified some compelling need and you need a little bit of extra time to get a permanent solution in place. But, by nature of the name of the tool, it is temporary. This land use regulation is temporary, and you need to come up with a permanent solution within 180 days. And then also recently there was language put into the code that you can't stack a temporary land use regulation onto a pending ordinance. And that's what that second part says. And we'll talk about pending ordinances a little bit later. And then additionally, there are only certain cases in which you can renew a temporary land use regulation. There's one case specifically, and it involves, read it, in an area where that is subject of an environmental impact statement or major investment study examining the area as a proposed highway or transportation corridor. In those cases, you can renew the 180 days up to 2 times, up to 2 additional 180-day periods. But outside of that narrow circumstance, a temporary land use regulation addressing a specific circumstance may not last more than 180 days. Okay, so now the question, right? What qualifies as a compelling countervailing public interest that would warrant the use of a temporary land use regulation that would put a pause on any approvals for, submitted or new applications? Compelling countervailing public interest is not a defined term in state statute. We don't have a ton of guidance, but the Western Land Equities case that we discussed previously does give us some really good guidance about what is a compelling countervailing public interest. And whenever I talk about people, I like to start by talking about what it is not, what a compelling countervailing public interest isn't. So in the Western Land Equities case, it was a situation where a developer, they were seeking to construct residences in an M1 zone. So it was a manufacturing zone, but it allowed residents by special permit. So again, administrative, right? As long as you can meet all the codes and comply with reasonably imposed conditions to mitigate detrimental effects, then it's entitled to approval. But the city looked at this and said, hey, it's one of those kind of typical scenarios of we don't think this is the right place for it. I don't think we meant to do this kind of thing. And you've probably seen that comes up every once in a while. This wasn't intended, right? And so some of the concerns raised by the local government, Logan in this case, in the Western Land Equities case, they looked at it and said, hey, there's manufacturing and industrial around the area. The site was surrounded by railroads on 3 of the sides, so inappropriate site for residential. There was sidewalk concerns. It was surrounded by railroads on 3 sides. There was access and fire protection concerns. But really, most of these could have and would have been addressed through the application of standards that were in the ordinances, right, for installing sidewalks and improving access and fire protection. And so really a lot of the concerns that were raised by the city looked more like policy considerations as opposed to, hey, there's something wrong with this application and it doesn't conform with the ordinance. And so to that, what, the court in Western Land Equities, you see there, it said, it is incumbent upon a city to act in good faith and not to reject an application because the application itself triggers zoning reconsiderations that result in a substitution of the judgment of current city officials for that of their predecessors. So it's not a judgment call, right? It's not a, hey, uh, we're not really sure we want this here, right? This isn't the right place. So the court didn't find that simply because the concerns were raised, a compelling countervailing public interest had been established. So a compelling countervailing public interest is not just speculation or conjecture about a matter. It's not a simple zoning reconsideration that results in the substitution of judgment of current city officials for that of their predecessors. Okay, so what is it? Again, from Western Land Equities, the compelling public interest may, when appropriate, be given priority over individual economic interests. A city should not be unduly restricted in effectuating legitimate policy changes when they are grounded in recognized legislative police powers. There may be instances when an application would, for the first time, draw attention to a serious problem that calls for an immediate amendment to a zoning ordinance, and such an amendment would be entitled to valid retroactive effect. Okay, so I have here an article from a newspaper from KSL, it looks like there. And this is something we got a lot of calls on last fall before our banner water year. There were concerns about water, right? Hey, if we approve another, application, then we're not going to have enough water. So a compelling countervailing public interest, it has to be a legitimate public concern. It has to be a serious problem that calls for immediate amendment to the zoning ordinance. It has to be something, a significant threat to public health and safety. Another example that regularly comes up is, you get an application, and that we've seen in the news recently. You get an application for a subdivision approval, and as the application is being reviewed, a neighboring, or let's say it's a building permit, right? A building permit for a home, and then the next day the house next door begins sliding down the mountain, right? That may be a compelling countervailing public interest that needs to be addressed before additional applications are approved. Okay. Any comments or questions? Will, I see you
Yeah,
coming up.
I just wanted to add to that. I mean, you explained it really well, and I often use the example of saying, like, it's got to be something on the order of magnitude of, houses are sliding down the hillside,
Yeah.
and it's really a big threat to public health and safety. Those are probably the kind of things that we're talking about with countervailing and compelling public interest. There is discussion about that, though, because apparently, according to the development community, there are some communities that are maybe using reasons that seem a little bit less severe than that. So there's been a little bit of a push to say we ought to define that in state code. And there's been real resistance from a lot of quarters, particularly from local government, saying, you start getting into defining what that is, it's a game that never ends. So we just urge everybody to be cautious about when they use that as a rationale.
Yeah. Thanks for that. Uh, Caution there, Will. And it is. I mean, defining terms in state code can be a two-edged sword, right? It, it presents some predictability and certainty, but it also tends to have sometimes unforeseen consequences of being overbroad, or in some cases too narrow, because you try to add a little too much definition, right, Craig?
Well, and I don't want to get us too far off track, but just for what it's worth, in a relatively recent case, the Supreme Court of Utah backed off of its previous statements as to how much deference the court's going to give to local decision makers. It used to be that there was some deference to the locals when they interpreted the ordinances and applied them. But in a case called Outlook Media versus Salt Lake City involving billboard advertising, the deference that the hearing officer in the district court had extended to Mayor Becker was ignored. And the Supreme Court said, we're not going to give deference. We're interviewing or we're reviewing the interpretation of local ordinances for correctness. And after they said that, the code was amended as well recently, so that now it says that the hearing officers, the appeal authorities, are to review for correctness.
Mhm.
So for what it's worth, I think that that's even more important, that we really find a compelling interest, that some of the extra flexibility cities have enjoyed in the past may be somewhat restricted compared to what it was.
Yeah. Thank you. And as I recall, it was done in a footnote nonetheless, right?
It was. That's true.
Which was interesting. Great. Excellent, excellent commentary. I appreciate that. Okay. So when talking about temporary land use regulations, those are some considerations and some concerns to keep in mind as local governments are using that tool, and that they're ensuring that they're doing it in a responsible way. Okay, so the last one we'll talk about is the pending ordinance rule. Okay, so going back to vested rights, as we said previously, an application who has submitted a complete land use application is entitled to substantive review of the land use applications um, uh, under the regulations in effect on the date the application is complete and applicable to the application or information shown. Here's the exceptions to that, right? So relative to a specific application, it's also entitled to approval if it conforms with all the land use regulations in place, unless, and we're going to focus on the second one, talking about pending ordinances, right? We've talked about compelling countervailing public interest, but in a manner provided by local ordinance and before the applicant submits the application, the municipality formally initiates proceedings to amend the municipality's land use regulation in a manner that would prohibit approval of the application as submitted. So this pending ordinance rule is a scenario where, in the ordinary course of governing, sometimes a local government gets a number of applications in that don't really produce the desired result, right? So as it relates to those specific applications, as they come in, they vest. But the local government has the ability to look at the situation and say, hey, we need to change the ordinance here, and we need some time to kind of tweak things and come up with a better plan. The pending ordinance rule allows for a scenario in which if you formally initiate proceedings to amend your ordinance, then you have this grace period, a 6-month period, in which for a time, any new applications that come in are going to be on notice, right? That, hey, as far as the rules that exist on the books, they may not be applicable to your application. So if you're going to do that, right, if you're going to enact a pending ordinance that puts new applications on notice and says, hey, your application may be subject to different rules, then there's a duration, right? So the municipality, it has to be no more than 180 days, essentially, right? So you have 6 months from the time that you formally initiate proceedings to amend your ordinance until you enact a permanent ordinance within which to come up with a new ordinance that will be applicable to those applications, right? So again, from a moratorium standpoint, you can tell new applications that are coming in, hey, we need to put a pause on your application here because there is a pending ordinance that has been initiated, and if a permanent ordinance is put in place as a result of the pending ordinance, then it will apply to your application and it will change the rules applicable to your application. So again, you have 180 days to do that. And again, there you can see in the capital B, you can't stack that onto a temporary land use regulation. And then furthermore, you need to provide some detail to the pending ordinance. So again, it says that the pending ordinance would amend the municipality's land use regulation in a manner that would prohibit approval of the application as submitted. So this requirement indicates that, when you're noticing, and again, some people say, okay, what constitutes formal initiation of a procedure to amend the ordinance? You should put it in your code, and I have an example coming up that does that, and is a good example of that. But if there isn't anything in your code that indicates what formal initiation of a procedure to amend your ordinance is, then most agree that if you've put it on an agenda and notice that agenda, then you've probably formally initiated proceedings. Now, that notice that you provide, right, it should include enough detail in the form of the proposed ordinance that a person could determine that the ordinance, if approved, would indeed prohibit approval of the application as submitted. So it can't just be a general, hey, we're looking at things, right? Our ordinances are open, and anyone who brings in an application is on notice that we're not going to approve it. You have to be specific. You have to provide detail so that someone reading it would look at it and say, oh yeah, this is going to apply to my application. So here's an example. I pulled it from Linden City. It was an ordinance that I was aware of that had defined in their code, right? So it lays out and specifically says Linden City formally initiates proceedings to amend this division when it gives notice, according to section of code, of the first public hearing in which the proposed amendment will be considered. So it's provided that notice. Everyone knows and is aware, okay, this is when we have formally initiated proceedings, and that begins that 180-day period, the moratorium in which new applications are on notice that, hey, the rules might change. And then I also put in this provision about notification of pending land use ordinances. So it's good. These are good provisions to have, right? When the council determines the need to adopt or change a land use, the city council shall pass a resolution notifying the public that the city is considering the adoption, amendment, revision, or change, and shall identify the specific ordinances. So there's the specificity, right? And or zones to be affected. So that's a good provision. And then applications for building or use permits filed after the passage or resolution of a resolution pursuant to the section will be subject to any conditions or requirements. So it lays it out clearly, right? And then upon receipt of an application for new permits, the building official receiving the application shall notify the applicant of the pending ordinance. And so let me also say here that this points out an important consideration with both temporary land use regulations as well as with pending ordinances. I'll get people calling in saying, hey, there's a pending ordinance in place, or there's a temporary land use regulation in place, and the city turned away my application. That's not allowed. You can't do that. You have to receive the application so that essentially that application gets its place in line, right? Because again, if the 180-day period lapses, then the code says that and a permanent ordinance hasn't been enacted, then that application is vested on whatever the rules were in place at the time that application was submitted, right? So it's very important that local governments always receive the application, get it in line, so that as things proceed, there aren't any questions about what rights they do have in those circumstances. Craig,
just a little comment on the ordinance draft. That, by the way, it says that anytime the city is going to consider a change, I'm not sure you want to put that language in your ordinance. You don't want to necessarily have to pass a resolution before you can consider any zone change. But if you do want the zone change to be a pending ordinance for purposes of the vested right rule, then you should. And so just a cautionary note about the exact wording of that sample. This is excellent, Jordan, doing a great job. Thank you.
Thank you. Okay, and we're about done. So yeah, that's the pending ordinance provision and the pending ordinance rule, and just kind of some considerations to keep in mind, both as a local government and as an applicant, about what the details are there. So in summary, when to use each tool, the pause on zone change requests. So this is a brief summary of as I see it, when each tool is appropriate to be used and under what circumstances. So saying, hey, we're not accepting any new zone change applications. So the entity is putting together a thoughtful zoning scheme for the first time in a while, and would like to get it in place before considering new zone change requests. say, hey, we need to do some studies. We need to look at some things. They're looking at your planned capital facilities and services, and you've determined that your existing zoning is going to be inadequate. And so you need to come up with a new plan for providing services or increasing intensities or right sizing development to the resources that you have. But again, it should be a temporary solution. And you should work fast to get in place ordinances that will reasonably and thoughtfully guide future growth. It's done as a matter of policy within legislative discretion. So you don't need any formal resolution or ordinance. You just kind of need agreement and understanding. Um, Temporary land use regulations should only be used in urgent and unforeseen emergencies supported by facts and data, and they are by definition temporary. And then pending ordinances are appropriate when the entity identifies an area of the code in need of improvement or modification. They're part of the ordinary course of the public process, and they temporarily hold new applications to allow time for pending ordinance changes to be enacted for 180 days. So with that, I do have, do we have any questions?
We do.
Also, oh, we do. Okay. I'll put
We
up my
do.
information here. Give me a call if you have any other questions or want to talk specifics, but yeah, what do we got?
Okay, so here's a question from
And Craig and Wilf, I welcome your thoughts as well, obviously. So
thanks. So this question, can you explain what might happen when a submitted application moves towards approval by the land use authority and the pending ordinance period has not concluded?
okay. So what might happen when a submitted application moves toward approval? So in that case, as I understand it, the applicant can be told, right, that, hey, we have this pending ordinance in place, and you need to wait until at least the 180-day period has elapsed before we before we have an obligation to formally act upon your application. Now, the local government can enact a permanent land use ordinance prior to the 180 days, right? So if something gets in place, then it's the obligation of the local government to move forward on that new ordinance, whatever it may be, to see if the application conforms, right? But otherwise, the local government does have the ability to, for that 180 days, hold the application. Now, if the 180-day lapses, then on the 181st day, the local government needs to process the application based upon whatever the ordinances were that were in place before the pending ordinance started.
Well, and just to emphasize here, this is optional. You know, the local government doesn't have to hold up permits while it's considering a change in the ordinance. And there's middle ground as well. You know, there might be a change in some part of the ordinance that doesn't necessarily mean the entire process of reviewing the application has to be held up.
Yeah.
The application could proceed, and a lot of the factors considered, but not finally approved until the city has finally decided, for example, what will the setback be in the R2Z3 zone. So there's some flexibility here, and it's not meant to be rigid.
Great point.
Another question, how do we as a planning commission explain to residents of smaller cities the need to offer a variety of housing options so as not to be discriminatory?
Oh boy.
Okay, Jordan, take it from here. I only laugh because, you know, we have been talking, those of us who have nothing better to do than ruminate about land use issues. We've been having meetings and talking, and at the end of the year, summer reports are due, and there's a lot going on as the legislature convenes. And this is really where we're living. This is the air we're breathing right now in the land use arena. Because we don't know what the legislature might do to reinforce this duty of local governments to be inclusive, using the word duty politically and not legally. We don't know what the courts might do. We don't know necessarily what the executive branch will do. The governor has instituted a dramatic new plan to promote first houses for starter homes. So Jordan, what is the approach that planning commissioners should take to explain to the public and what it means to review things without a discrimination, without a looming discrimination charge?
Yeah, it's a great question. And, I welcome Craig and Will for your comments on this. I always appreciate the approach, and you've heard this before, right? But our decisions need to be evidence-based and data-driven. And I think if you do things in that way, then, it's understandable and it's rational, to, like the question indicated, to the public, hopefully, right? And it doesn't come across as being viewed as arbitrary and capricious or discriminatory. Um, you know, the court standard is that the decision just has to be reasonably debatable to be in the public interest. But decisions are always better, again, if they are supported by good evidence and if they are driven by good data. And so, that does take a lot of effort on the local government's part, to go out and maybe spend some money and hire some consultants and refer to some experts, and learn, right, kind of what the value is for your community specific. Because again, I recognize that each community is different, right? But it is also important to recognize that each community, provide housing for everyone who lives and works in that community. That you can't, reap all the. I saw this quote somewhere. I can't remember where right now, but you can't reap all the benefits of economic growth without also addressing its burdens, right? And so, every economy needs, um, people who are, number one, all types of workers and all scales of income and all ages, right? And so ensuring that there is a variety of housing types, that are available to each individual that's in our community, um, is important. It needs to be addressed. So.
Maybe if I can just add to that a little bit. I mean, I think a lot of times when you have situations where a community feels like that they need to make a change to their zoning code, it's oftentimes based on a specific example. An application comes in for a specific kind of use or for something specific, and everybody in the local council and maybe even the planning commission is going, "Oh crap, that's not what we wanted." Or the residents come in and raise a big fuss, and everybody says, "Wow, maybe we should look at changing that." And I'd urge caution again on those, because you want to think it through. And I think that's why it's good to have a 6-month period. Gives you some time to really think it through and look at more than maybe just that one example. And maybe you ultimately decide and conclude, well, maybe it is okay. Maybe it's a good thing to have in the community. And I think as we certainly face the potential of having more specific guidance from state policymakers about, at this point, housing, maybe some other things. We do need to be careful and make sure that we're in compliance with all of those things. Um, that legislative discretion may be a little bit more curtailed than maybe what we think.
Well, and if I might just clarify something I said earlier, I referred to the Utah Enabling Act as including a provision promoting modern income housing. And in fact, I was wrong about that. I've always thought it was incorporated within the Enabling Act very clearly by the requirement for the modern income housing plan as part of the general plan. But now I remind myself, it's the legislative auditor general who published a report in the last couple of months about the effectiveness of the modern income housing plan program. The recommendation of the auditor general was that be included specifically as one of the purposes of the Land Use Management Development Act. So we may see that coming this session as well.
Well, thank you, Craig. That includes my presentation, and I'll turn the time back to you. Thanks.
Thank you. Well, this is wonderfully done, Jordan. And again, the PowerPoint is like a handbook. There are terrific resources there, and the outline has been very well presented. So thank you so much. We again appreciate the Division of Housing and Community Development who provided the money for this. And we also appreciate the Ombudsman's 1% building permit fund, which will help cover the cost of keeping resources like this in the Utah Land Use Library. That's utahlanduse.org. Hit the library tab. So thank you, and we'll conclude our program for today. Thank you very much.
Thank you.